Greetings, pot pickers. This is Keri Tayler, and I'm a member of the Court of Protection team at No5 Chambers. Yes, I know you're all here for a podcast about recent developments in the Court of Protection, but it's probably the only time I'll get to say that to a broadcast audience. Anyway, it gives me great pleasure on behalf of No5 Chambers to introduce and chair this second podcast in the series, entitled Conducting Remote Assessments in the Court of Protection and the Least Restrictive Principle. We will start by hearing from Tim Farmer, an independent mental capacity assessor who's conducted a possible record-breaking 47 remote assessments since the start of this public health crisis. We will then speak seamlessly to Alison Harvey and Laura Davidson, fellow members of Chambers, who will speak about the case of BP. Alison, who appeared in the recent case, will provide us with a factual account of the principal issues, and Laura will provide her insights into the impact of the judgment. So Tim, thanks very much for joining us today. 47 assessments is quite some tally. How have they gone?
Hi, Keri. Yeah, 47. It's been quite busy. How have they gone? Well, some have gone really well. Some have gone not quite so well. But I was thinking, I was reflecting about this over the weekend, and I was thinking to myself, of those that didn't go quite so well, would they have gone any better if I'd seen them in person? And I think overall, the answer is probably not. Because I think it's fair to say when we do face-to-face assessments, some of them go well, and some of them you feel are quite easy and not that difficult to unpick, and others are still quite difficult, and it doesn't change with the medium. And to give you an idea of the range of assessments that I've done via video link, so age-wise, from the ages of 15 up to 109, with a whole range of cognitive impairments, ranging from schizoaffective personality disorder through strokes and dementia to brain injuries and cerebral palsy. Most of them have had some sort of communication impairment, be it one person that I saw that was deaf and mute, to somebody else that would only or could only communicate through an iPad, or someone that had such a bad effect in terms of Tourette's that actually they weren't able to speak for minutes at a time because of the impact of the communication. Like I said, with each of those, I kind of reflected on, if this had been face-to-face, would it have been any easier? And I think for a couple of them, there might have been issues around engagement that might have been easier on face-to-face. And I'll talk a bit more about engagement at the end. But overall, I don't think, well, certainly the outcome wouldn't have been any different. Now, when we think about capacity assessments over the video link, and anybody that's heard me speak before, when we talk about face-to-face assessments, for me, the real key to achieving a good assessment, whether it be over video link, whether it be face-to-face, is the pre-planning. And I can't stress enough the importance of the planning for what you do before the assessment. And anybody that heard me talk over the last few years know that I bang on time and time again about setting the threshold of understanding and the real importance of knowing this, because if you don't know what they need to understand, how can you determine what questions to ask? And it doesn't matter whether that's face-to-face or whether it's over video link. If you ask the wrong questions, you're going to get the wrong outcome. And until you've set the threshold of understanding, until you've worked out what it is they need to understand, how do you know what information they're going to need and what information you're going to need to gather? So the next step of the planning is, once you've identified the threshold of understanding, it's about saying, right, what information do they need? What information do I need? How do I provide this to them? And how do I gather it from them? And a lot of times it's in the same way you would in a face-to-face assessment. But there are a few practical tips and tricks that when you're using a video cam that just make it so much easier. So the first thing, and the thing I teach a lot of people, I have been over the last few weeks, is about how to use a screen share. So a lot of people that we work with, if they've got brain injuries or sometimes other conditions, are much better at visual information than they are at audio information. And so quite often, say if we're doing an assessment around problem financial affairs, I will show people pictures of coins. And I do this through the screen share. So I've got a Word document with all different pictures of coins and notes, and I will just share my screen and I will bring that up. And I will, if it's too small, I will use the enlarge on my screen to make it bigger on their screen. I will often draw on the screen using the draw function. And so whatever I draw on my screen will go onto their screen. And so that way you can start to share information. Another really good tip that I've come across is if you are expecting somebody to work with documents, then where possible, ensure that they have a hard copy of the documents in front of them. And what I've done for a couple of assessments is I've got a person at the other end. So I think about one gentleman I saw, we had 4 or 5 legal documents he needed to go through, and I asked his daughter to number them. And I had a video meeting with her beforehand, and we put them in the order that I wanted to do the assessment in. And then I got her to write in the top corner in red felt tip pen, 1 circle for the first document, 2 circle for the second document. And on the third document, there was a specific paragraph that I needed to go through in quite a lot of detail with him. And so I said to the daughter, I want you to highlight this paragraph. I said, what colour highlighted have you got? She said, well, I've only got a blue one. So I said, okay, I want you to highlight it. And I highlighted it on my screen in blue. And she then found it on hers and highlighted it on her bit of paper in blue. And that meant that when I was going through the document with the individual, I was able to ensure that we were looking at the right document by saying, we're looking at number 1 documents that look in the top right-hand corner. And then when we came to the highlighted bit, it was the same colour on my screen as it was on his documents. So it became very easy to refer to the specific document and the specific part of it. And on reflection, had I been there face to face, could I have used a more effective tool? Well, I might have been able to point to it in person. But actually, that seemed to work really well. And so, it comes back to this real importance of the planning and about saying, what is the information that I require? What is the information I require to support them? And if we think about the second principle, about supporting the individual to be able to make the decision, I think this fits in really nicely with that. And it also, as you're doing that, enables you to start to think about, okay, well, what is this person's condition? What is their presentation? So how do I now present this information in such a way that it is applicable to them in a way that they can use? Now, I mentioned earlier about engagement and whether any of those assessments that I'd done would have been better with a different level of engagement. And another top tip, I suppose, that I've come across is about the use of a third person in the assessment. And a really good way to illustrate this is one assessment I did on the lady who was both deaf and mute. And again, I thought to myself beforehand, if I had seen this lady face to face, how would I conduct this assessment? And I mean, the answer is obvious, isn't it? You have somebody that speaks sign language, same mode of sign language that she did. So we had that interpreter there, and so I spoke to the lady, the client, directly. She then looked at the sign language interpreter who interpreted it, and they had the conversation, and then the interpreter kind of explained to me what the lady had said. And that technique works really well for everybody. So there have been a number of times in a care home where I've known that they are confused, their attention span is short, but actually having a member of staff next to them. So when I show a picture of, say, a pound coin on their screen, and I ask the individual what it is, to have the carer then say, "Look, Joan, Tim's put it. What's that coin you can see on the screen? Can you tell Tim what that screen is?" And again, it's that second principle of supporting them, the individual, to be able to engage with it. And I think that as long as you have the other person there on the screen at the same time, so you have them sat next to each other, that way you can see what they're doing, you can engage, you can instruct if necessary, and you can also observe for any signs of duress or undue influence. I suppose the other real key thing when we're talking about engagement is structure, and structuring the assessment in such a way that if you know your client's got a 5 or 10 minute engagement span, then you break it down into the 5-10 minute slots. Again, this comes back to the importance of planning. And actually, when you think about the use of the documents that I was talking about earlier, that a number that also provides a really good structure, because you can say, we're just going to talk about this document now, document 1, boom, boom, boom. And I found that using that planning the structure carefully and using the third person has pretty much overcome any of the issues around engagement. I suppose the other practical thing I'd be saying is think about the platform. Now, there's a lot of anxiety out there about people not being able to engage in the technological side of this. As I said, the 109-year-old lady that I assessed was absolutely bang on with it. And I'm finding that the anxiety sits more with us than it does with the individual. Most of the people that I speak to in their 70s and 80s, they're using Skype to talk to family members. I even did an assessment on a person with schizoaffective personality disorder. And part of their condition was they didn't like talking to people. They self-isolated, and they wouldn't engage. And this person, we did it over WhatsApp. He'd never had a smartphone, never seen WhatsApp. He wouldn't shut up. He was saying how amazing the technology was. And he just kept talking and talking and talking. And that actually made the assessment a lot easier than if I think I'd seen them in person. So I think there are pros, definite pros to doing it over video conference. And I fully expect that once the lockdown's lifted, for this to be an acceptable way forward for doing it. So I know it's a very high level overview of some of the stuff around video assessments of capacity. But I hope that's been useful and insightful for people.
Thanks very much, Tim. That was really interesting and engaging. You've sort of answered the question I was going to ask you in a way, but we'll hear from Alison in a minute about the reluctance of the psychiatrist in her case to undertake a remote assessment. And I suspect for those of us practicing in the Court of Protection, it's not unusual that there is this reluctance and, in a sense, great mystery about doing these things online. Do you have any sense as to how quickly these assessments and remote assessments might become more acceptable to practitioners?
Well, I'm hoping that the more we do them, the more acceptable they'll become. I mean, I think if we're realistic about lockdown and the impact of the COVID-19, people in care homes and visiting the care homes and hospitals, I suspect, are going to be some of the last places where the lockdown is lifted. And that means that we're going to have to keep using this medium. And the more we use it, the more we get used to it, I think that the fear and the anxiety that's built up around it will be dissipated. And as such, I think very quickly we're going to see an acceptance of this form of approach to capacity assessments.
That's great. Thanks so much, Tim. I think we'll all agree that little talk will be interesting both to those who are undertaking assessments and might be concerned about undertaking these assessments, but also to lawyers who may be examining assessments and be looking at them to consider whether they have been sufficiently rigorous or not. So moving on to Alison, if we may, those listeners who are already familiar with the case of BP will know that these remote assessments became quite a significant issue in that case. So Alison, do you want to give us an overview of the issues in that case and how they were resolved?
Thank you, Keri. The case of BP involved a man in a care home with dementia who was also profoundly deaf. BP was engaged with the world around him. His family visited every day, and he'd go through the newspaper with his daughter. So he knew that there was a pandemic out there, unlike some people in care homes who have no concept of what is going on. The proceedings were already live before the Court of Protection because there was disagreement between his attorneys, his wife and his two daughters, as to whether he should remain in the care home or return home. The care home went into lockdown before the government imposed lockdown. That's how the case came on so quickly. And the case unfurled against a changing background of new government guidance followed by regulations as to what care homes and indeed what all of us should do. When the care home locked down, before the government required it to do so, it banned all visits. So the family visits ceased and the mental capacity assessor was not permitted to enter. As Mr Justice Hayden put it in the case, the effect on BP was seismic in terms of the change to his life. In our case, what we wanted was to get a thorough examination of whether BP should go home. And we had first to decide whether we were going to try and challenge these regulations as part of the Court of Protection proceedings or seek to bring a case in the administrative court. I would advise practitioners, whatever your challenge, however systemic it feels, to think very carefully. The advantage of the Court of Protection is you have ongoing proceedings. You have the best interests of P at the centre. The local authority has a clear responsibility as the supervisory body of the standard authorisation. And in a case of a judicial review, you have to show that you have exhausted alternative remedies. The other strong advantage of the Court of Protection is that it can deal with matters logistical and practical. And therefore, if we were going to achieve what we wanted, which was to get BP home, that was clearly going to involve practical steps, care plans, assessments, stair gates. The Court of Protection was for us the place where we felt we could move more quickly, as indeed we did. We put in the application on a Monday. The judge agreed that day to transfer it to a Tier 3 judge. The transfer was made the next day. We were before a judge by the Thursday. And we were arguing that the complete lockdown prevented an assessment of BP. He'd never used a smartphone. He didn't use any remote means of communication. He would talk to people. They would write things down from him. His communication was face-to-face. And clearly, this was a case where capacity was borderline. So we felt that any assessment would be open to challenge from one side or the other in those circumstances if done by means that were wholly unfamiliar to him. He could recognise that it was his family on a screen, but not that they could hear him. He thought it was like watching television. So our argument was, if the assessor can't do the assessment, and the assessment is a precondition to deciding whether he can choose to leave the care home, then this is interfering with his Article 5 rights. Plainly, the ban on family visits was an interference with his Article 8 rights. So we came before the Court of Protection, before Mr Justice Hayden, the Vice President, and we argued that BP should be allowed to go home. The judge was very clear that every effort should be used to ensure that a person could communicate with their family. And the resulting compromise, negotiated very much under his supervision, was that the family would be allowed onto the premises to communicate with the care home, to communicate with BP through the window. The judge ordered that the care home look into remote means of communication and how the care home staff could facilitate that in the event, because everyone used the window option, that wasn't explored further by either the care home or the family pressing for it. So it simply sat there in abeyance. And so we negotiated that agreement, and the judge took the view that an assessment could be attempted remotely. Now, there the case might have ended, but the judge had made some remarks about derogation from the European Convention on Human Rights. We had simply said, as a throwaway line almost, Article 5 applies, Article 5 is not a balancing right, it is an absolute right with specifically defined exceptions, same structure as Article 2. This isn't about balancing one set of interests against another. And there is no derogation. So Article 5 applies read in tooth and claw. Now, the paragraph of the judgment we read, as did a number of academic and human rights commentators, as suggesting that an individual judge could derogate from the European Convention on Human Rights. That led us to put in grounds to the appeal at the Court of Appeal. The judge indicated that he wished to deal with it at his level and clarify his judgment, and that is how the second case of BP came on before the court. We were prepared for him to deal with it at his level. Our argument was, it looks as though your decision that the assessment could be carried out remotely, and possibly your approval of the structure for family visits, was only lawful because you assumed there had been a derogation, and you might not have found it to be lawful under Articles 5 and 8 without amendment. Therefore, the judgment cannot stand, and these issues have to be re-examined. In the interim, before getting back before the judge, things moved on. The guidance, the regulations were coming out apace, but also BP fell very ill. There were fears he had the virus, he didn't. The care home didn't have the virus at all. But his illness and his mental health suffering because of the isolation, which led to him being prescribed antidepressants, led his wife to change her mind and conclude that he should go home. The local authority, by the time we got back before the judge, also were willing to support a return home. So we came before the judge. He clarified that he hadn't meant a judge could derogate after all, and he agreed to order BP's return home, subject to investigations of the practicality of that. And that's very much the focus of the second judgment. I was disappointed that he did make it... Sorry, I'll go back. By that time, the doctor who was to have carried out the assessment had reviewed the papers and said, in the circumstances of this case, I, a consultant psychiatrist, do not consider that I can carry out a sustainable assessment remotely. Now, in the event, we didn't pursue that because BP was going home. Everyone was agreed that the assessment could wait until he went home. But the judge made it very clear that if this consultant psychiatrist had not been prepared to attempt a remote assessment, then somebody who would have had to be found. That troubles me. I am concerned that in the end, the mental health professional is probably the best judge. And as I say, this was a borderline case. What we don't want is these assessments of capacity dragging on. So if you're going to have an assessment that is extremely vulnerable to challenge by one or other party, that isn't going to bring you rapidly to a conclusion. And my feeling was that was a real risk in the case, and both BP's Alzheimer's and his deafness brought into play the question of both BP's Alzheimer's and his deafness brought into play the duties under the Equality Act, including the duty to make reasonable adjustments, and thus what is acceptable in terms of remote means of communication for someone who has all their faculties may not be for someone who does not. I would only add one thing that's not directly on remote assessments, but on remote hearings. The local authority had challenged the daughter's appointment as the litigation friend, perhaps unsurprisingly, in a warring families situation. The daughter was phoned into the first hearing. She spoke to the judge on the telephone, on loudspeaker. In the event, she retained her position as the judge, as litigation friend. The judge was absolutely persuaded that she was taking a disinterested view and seeking to put her father's position before the court. And I felt there that it wasn't so much that we overcame the technical hurdles, but rather she was actually less nervous because she was sitting in her own front room on the telephone, speaking to the judge, far more at ease and forthright than she might have been if she'd hung around while we negotiated draft orders and visiting rights in the courtroom, didn't have to look at the family members in the circumstances of difficult family dynamics. It wasn't that we overcame the technical barriers, it was, as in the case Tim described, that those barriers worked for this particular situation and made it easier.
Thanks so much for that, Alison. Now, yours was one of the first cases, certainly the first reported case, dealing with remote assessments. We've heard from Tim how many he's undertaken, and I think most of us now have had cases where remote assessments, whether of capacity or care needs, have taken place. Do you think now that barriers might start to come down in terms of these remote assessments?
I remain concerned, particularly in these borderline cases. I think I have had a couple cases where there is a very live question in the proceedings as to whether the person has capacity. And I think in those circumstances, if an expert were to determine that they didn't, in circumstances where the assessment had been done remotely on technology with which they were unfamiliar, they would be pretty vulnerable to challenge. Equally, if it were found that they did have capacity, I think they would also, in those borderline cases, be pretty vulnerable to challenge. So I'm not sure how well they're going to work in the context of litigation.
That's great, Alison. Thank you so much. Now we move on to Laura Davidson, who's been waiting patiently whilst we hear from Tim and Alison, and no doubt will tell us her impressions of not only what they've said, but some of the main learning points from the case. So, Laura, do you want to give us a bit of an outline on what you think the main impact of the judgment will be going forward?
Thanks, Keri. It's a really fascinating case. As you say, it was the first reported quarter protection case undertaken remotely. And I know Alison had to deal with all sorts of technical hiccups and a rapidly changing legal context. The court had to consider guidance from both the judge and the government, superseded by new circumstances and further guidance within a week. The initial guidance told care homes to review visiting policies, taking into account the positive impact of seeing friends and family. But then the updated guidance, actually issued on the date that BP applied to court, did a U-turn and introduced a blanket prohibition on care home visits. As a human rights barrister, for me, the case was particularly interesting because of the powerful and competing rights and interests engaged, as the judge rightly observed. So, for example, under the European Convention on Human Rights, Article 2 was clearly engaged due to the heightened risk to BP and other residents from the virus, and also from visitors who might be carrying it, although this wasn't specifically discussed in the judgment. Article 5, dealing with the right to liberty, places a positive obligation on the state to take measures providing effective protection of vulnerable persons, including reasonable steps to prevent a deprivation of liberty. Article 5.1 also protects security of the person, and I thought that was an astute observation by the judge in the context of the pandemic, since it's much more common to conflate the term liberty and security of the person and only really focus on the former. Article 8 is also involved in this case, and it relates to the right to family life. But, of course, as Alison has said, it's not an absolute right because there may be interference with it by a public authority, provided it's in accordance with the law and is necessary in a democratic society for the protection of health here. And that clearly applies in relation to the COVID-19 crisis. Article 15 is perhaps a slightly lesser known article because it permits derogation from Articles 5 and 8, and those would be rare circumstances. The court here held that it applied to the pandemic, but emphasised that any derogation requires powerful reasons confirmed on solid and compelling evidence within paragraph 27 of the initial judgment. The judge found that there was a public emergency threatening the life of the nation and that derogation was required, but only to the extent strictly required by the exigencies of the situation. It was interesting to see that the Convention on the Rights of Persons with Disabilities was considered, and I'm glad to see that, because it's also clearly relevant. Those with long-term mental or intellectual impairments are included within the definition of disability in Article 1 of the Convention. Under Article 11, entitled Situations of Risk and Humanitarian Emergencies, states must take all necessary measures to ensure the protection and safety of persons with disabilities in situations of risk, for example, during a pandemic. And Article 25 of the Convention of the Rights of Persons with Disabilities protects the right to health for those with disabilities. The court also had to consider 20th of March 2020, Council of Europe's European Committee for the Prevention of Torture's Statement of Principles relating to the treatment of individuals deprived of their liberty in consequence of the COVID-19 pandemic. That's quite a mouthful, and amongst other things, what it stated was that there must always be consideration of any alternatives to a deprivation of liberty, including release to community care for those in care homes. And it's the principle of least restriction I'd like to consider in a little more depth here. Article 5 of the European Convention on Human Rights is a fundamental right, but it's not absolute because there are exceptions within Article 5 itself. It's Article 5.1e, which permits the detention of those of unsound mind, which is the very foundation of mental health legislation in the UK and the deprivation of liberty safeguards. However, the principles of least restriction and detention as a last resort are so universally accepted that they're arguably now part of customary international law and binding globally. Of course, they're also codified in Section 1.6 of the Mental Capacity Act 2005, which states that before the act is done or the decision is made, regard must be had to whether the purpose for which it is needed can be as effectively achieved in a way that is less restrictive of the person's rights and freedoms of action. Thus, consideration must always be given to the possibility of less restrictive options for delivering care or treatment that avoid deprivation of liberty altogether. As the Deprivation of Liberty Safeguards Code of Practice makes clear in paragraph 2.7, any restrictions placed on the person while in hospital or in a care home must be kept to the minimum necessary and should be in place for the shortest possible period. But as we all know, respect for an individual's view doesn't trump acting in that person's best interest, which is the ultimate principle underpinning the Mental Capacity Act and the DOLS. Those caring for persons who are subjected to the latter regime must carefully balance competing rights when making decisions and providing care, although ultimately best interest is the litmus test. As the Mental Capacity Act Code of Practice states in paragraph 2.16, any decision or action must still be in the best interest of the person who lacks capacity. So sometimes it may be necessary to choose an option that is not the least restrictive alternative if that option is in the person's best interest. Yet, the rights to autonomy and self-determination are protected by a plethora of international conventions. For example, Article 3A of the CRPD demands respect for inherent dignity, individual autonomy, including the freedom to make one's own choices, and independence of persons. Add to this legal conundrum COVID-19 and the question of where the balance lies in terms of best interests, and the definition of the least restrictive environment becomes immensely complicated. BP had always wanted to return home, and his daughter wanted him home too, with some misgivings. But his wife did not. This is quite a common scenario in COP cases, but suddenly there were additional considerations on the need for restrictions within both the care home and the community environment in the rapidly altering contextual situation. Regulations gave power to care home managers to prevent visitors, an extremely important element of someone's care and generally very much in their best interests. Many care home residents wouldn't want to continue to reside somewhere where their loved ones weren't permitted to visit and or were unable to communicate effectively with them. I put it that way, of course, because in BP's particular case, the order meant that his daughter was able to visit and wave to him through his window, but he was deaf. Even with his communication board, it proved very difficult to communicate with him in any meaningful way, and in comparison to his previous family interactions, this was a highly detrimental change for him. The new restrictions introduced by the regulations will also prevent some of the checks and balances inherent within the primary legislation from being effective, or at least from being as effective, perhaps, such as visits from NCAs, best interest assessors, and independent social workers and psychiatrists.
We've already heard from Alison that the court-appointed independent psychiatrist didn't feel that a remote capacity assessment would be appropriate and sufficient in BP's case, and thus declined to undertake it.
That scenario might potentially mean that BP's care was not best met in the care home any longer. Add to that the high risk to residents of the virus in terms of their vulnerability due to their age and the increased likelihood of underlying physical conditions within that cohort, and one can see a strong argument for continued detention no longer being in a resident's best interest. In those circumstances, was SH care home the least restrictive environment for BP? Even FB, his daughter, was concerned that she might not be able to look after her father without additional paid help, which is difficult to find currently. In these unprecedented times, there are many thousands of people residing in care homes because our economic and social systems require relatives to work full-time and they're unable to look after their loved ones. Now that everyone's at home in lockdown, with many more who have lost their means of employment or who are furloughed or unable to work for practical reasons, returning home may well be a viable, less restrictive option. The case rightly focused on BP's best interest, but an interesting aspect of it, in my view, relates to the judge's take on derogation, which I'll only mention briefly as my time is nearly up. Mr Justice Hayden clearly believed that derogation from certain ECHR rights was required. In fact, he said it wasn't merely justified, but essential. Why? The point is over, but it's an interesting question nonetheless. In paragraph 27 of the judgment he held, I'm clear it is not essential to signal in advance a notification of derogation to the Council of Europe, and then said, I will send notification of my decision, and proceeded to set out limitations of the derogation, such as that it was to cover only a limited period during the unprecedented public health crisis. It's unclear which rights the judge considered were being violated by the exigencies of the situation, thereby necessitating that derogation. Even after the second judgment on the 29th of April, that remains unclear. BP was lawfully detained in accordance with Article 5, which is subject to exceptions, and Article 8 is not absolute. Two sets of regulations provided a legal basis for detention powers to curb the virus spread. If, for example, the judge had forbidden BP's return home, despite finding that to do so would be in his best interest, that might have required a derogation from Article 5 pursuant to Article 15, but he didn't. The judge, however, did clarify in paragraph 9 of the second judgment that he hadn't intended paragraph 27 of the original judgment to mean that he himself would inform the Council of Europe of the UK's derogation. Indeed, it's quite clear from Article 15.3 of the European Convention on Human Rights that it's the state itself which must inform the Council of Europe about it. The judge stated on the 29th of April that his intention was for the court to inform the government that the Council of Europe should be notified of a derogation.
Hi, Laura, it's Tim Farmer here. That was really interesting. I wonder if there was one bit of the case or the outcome that you wanted to highlight, or one takeaway point. What would that point be?
That's a good question, Tim. I think it's difficult to pinpoint just one key takeaway point because so many aspects of this case were noteworthy. But I think for me, it's particularly fascinating because there's almost been a kind of role reversal in this case in terms of deprivation of liberty. So, I mean, we're all in lockdown just now, and who could even have imagined that that was possible a couple of months ago? And we're all subject to various restrictions, yes, with consent, to some more than others perhaps. But in the end, this case turned on the restrictions upon the visitors rather than the restrictions on the person who allegedly lacked capacity. The care home was obliged to close its doors to visitors, and ultimately, instead of it being a question of whether or not the type and level and frequency of restrictions on the person alleged to lack capacity cumulatively amounted to a deprivation of liberty, it was the restrictions on others which were key in this case and ultimately led to the decision by the court that BP should go home. And to me, that's the particularly memorable part, and it's the reason why this case is going to be remembered.
That's great. Thank you so much, Laura. It just leaves me now to thank Laura, Alison, and on behalf of Number 5 Chambers in particular, our guest speaker, Tim. And then to all of you patient listeners who are still with us, I hope. Well, at least if you're hearing this, you are still with us. So stay well and keep your eyes peeled for the next instalment. Thank you very much.